I can't tell you how many clients have said to me over the years, there's no hard evidence, or it's all circumstantial, or it's just my word against hers. How can the Crown secure a conviction with a trial judge or a jury? And I need to answer these questions for them. And I'm going to break down today terms that some people use. It's not really a legal term, and lawyers don't really use it much, but what's the difference between soft evidence and hard evidence in a Canadian criminal courtroom? We're going to talk about that today and how you can convict on either or a combination of both. So first of all, let's break down what soft evidence is. It's really testimonial evidence, oral evidence from a witness. For example, a complainant in a sexual assault trial will testify. She'll give a statement and she'll testify in court. And there may be no hard evidence, make DNA tests or anything like that. And certainly a judge is entitled and does every day in Canada convict just based on the testimony, he said, she said case. So that's soft evidence. Think of it as oral testimony. Think of it as an expert witness coming to give in their opinion, but it's basically someone who has to get up in the witness stand and relate a version of events. Now, it's fraught with difficulty, and this is why we cross-examine on it, because human memory is subject to fallibility. First of all, we got credibility issues. Is the person a believable witness under oath? Number two, are they reliable? Are they relating their story accurately? For example, a person could see a robbery scene and think they have identified the right person, but they picked the wrong person of the lineup. So are they reliable? So there's two components to testimony that a judge or jury has to consider: is believability, that's credibility, number one, and accuracy, which is reliability. Now, so that's soft evidence. That's, some people call it that, lay people, but the courts we really call it oral testimony, essentially, right? Now, hard evidence, that my clients sometimes say that to me, is really physical evidence. This is what we think of like DNA left on a victim, bullet casings, the bullets, blood spatter, a video of the scene, a video, GPS records, emails. This is hard evidence. Now, hard evidence can prove a case too. Sometimes the hard evidence is pretty compelling because it's hard to, you're not challenging the credibility or reliability of hard evidence in many cases because it can speak for themselves. But sometimes hard evidence doesn't prove a case just because the DNA might be weak. There might be only matches. Oh, it could be the person. It could be not be the person. It's not particularly helpful. But oftentimes in a Canadian courtroom, when you have a combination of good soft evidence, in other words, good testimony from a victim, coupled with good hard evidence, in other words, let's say a DNA match, well, the accused can be pretty much cooked. But don't think that you can't be convicted in a Canadian courtroom on soft evidence, that is oral testimony. I mean, that happens every day. I have to explain to clients that a judge is entitled to find a complainant completely credible. A judge has to apply the WD test. If you testify in your sexual assault trial, for example, the judge has to say, there's a three-step test, the WD, which I've reviewed in other works. And basically, if you've testified, if you believe the evidence of the accused, you must acquit a judge or jury. That's the first step. Second, if there's a reasonable doubt in your mind from the evidence of the accused or other evidence that they've left in the defense, you must acquit. Even if you completely reject, a judge or jury completely rejects the evidence of the accused, is there a reasonable doubt based on the rest of the evidence? So it's quite easy, unfortunately, for some of my clients at least, to get convicted if they come across poorly in court and the victim comes across very well with no other tangible hard evidence, like physical, real evidence. So both styles of evidence are very important in a courtroom. Some cases have more of the other. Many Canadian trials, jury trials, serious cases have actually no physical evidence, and the person gets convicted just on the eyewitness testimony of the complainant or someone who saw the physical altercation or the robbery and whatnot. So don't think that a person cannot get convicted. And this is important why, without hard evidence, this is why it's important to hire a good lawyer who understands the cross-examination skills, who has the ability to break down a complainant who is not telling the truth, for example. Obviously, that's a skill that's developed in a courtroom. So there you have it. Those are the difference between oral testimony, which think of it as soft evidence, I don't want to call it soft, though, because it can be very compelling in some cases, and hard evidence can be weak in other cases. Some cases have a combination of both that are helpful. Some have weaknesses for both. So they both can have their weaknesses because, for example, DNA might not be conclusive at all. A blood pattern may not be conclusive that it was due to a murder at all. And video evidence may be inconclusive as well about whether the accused is the perpetrator. What if the video is grainy? So they both have their features that can be helpful and hurtful. In the hands of a good defense lawyer, his job is to create reasonable doubt based on both. And I have to educate my clients that just because there's no hard physical evidence in their case, that doesn't necessarily mean it's going to be an easy case to win. It really depends whether the complainant's credible and believable, and whether the accused, if they testify, are credible and believable, and whether a good defense counsel can create a reasonable doubt in that mind of a judge or a jury. So there you have it. That's the takeaway. Don't think of oral testimony and just a he said, she said case as always being a winner, although sometimes it's easier to win when there's no hard evidence. And don't think of hard physical evidence as always being conclusive either. The combination can be helpful, or there may be weaknesses in both. And the bottom line is the trier of the fact, whether it's a judge or jury, has to come to grips with it, assess the evidence, whether it's credible and reliable and conclusively points to guilt beyond a reasonable doubt, which is a hard burden to reach, and which is a reasonable doubt in the hands of a good defense lawyer can often be created. So there you have it. It's been a pleasure presenting this video to you today, and I hope you enjoyed it. And if you did, please subscribe to our channel, and we'll see you in the next video. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.